Hello, everybody, and welcome to our training module on sexual and other unlawful harassment. With you today, we've got myself, Jacob Cruz. I'm the compliance manager here at BC Forward, and I've also got with me Tasha Irving-Gillespie. She's our employer relations manager. And today, we're just going to provide you with some pretty essential training on sexual harassment within the workplace. Our key learning objectives that we're going to talk about today: one, we're going to define what is sexual harassment. Two, we're going to talk about specific examples of behavior that can be classified as sexual harassment. And then lastly, we're going to discuss what should be done if you hear about allegations of sexual harassment within your department.
You may be asking, why is sexual harassment training so important? Sexual harassment is illegal, and the organization is committed to creating and maintaining a workplace free of sexual harassment. We're also committed to disciplining those who are found guilty. Despite all of the high-profile publicity and costly awards employers have had to pay, the issue of sexual harassment isn't going away. If anything, the sensitivity has heightened or deepened in the last few years. Most managers are well aware of the obvious sexual harassment, but there are other situations that are more subtle that may get supervisors and the company in huge trouble. Defining sexual harassment is sometimes difficult because what matters most is the perception of the person who feels sexually harassed. What is perceived as innocent, such as a glance by one, might be a suggestive leer to someone else, but the intent of the look isn't as critical as its effect. If the person feels uncomfortable, they could file a claim of harassment. The courts define sexual harassment as unwelcome sexual advances and requests for sexual favors or other verbal or physical conduct of a sexual nature. Now, to many people, sexual harassment means a lewd comment or inappropriate physical contact, or a request for sexual favors in return for job security, or even a career advancement. However, sexual harassment is usually more subtle. One employee may enjoy complimenting his female coworker on how they look when they see them in the morning. Another might think that telling a dirty joke is fun, or it may encourage camaraderie. But such behavior can be legally defined as sexual harassment. Now, keep in mind, if someone complains, your opinion about the alleged behavior is irrelevant. You may think the compliments are innocent or that the jokes are harmless, but if someone perceives them as a problem, they are a problem.
All right, now we're going to go into a little bit of an overview of the laws against sexual harassment and just kind of do a little bit deeper dive into how those affect workplace conduct. So first thing, who is protected by the law? In most cases, the sexual harassment laws cast a very broad net on who is going to be protected. Typically, we're going to be looking at employees, applicants, contractors, volunteers, and unpaid interns. So what's really important to take away from this is it's not just employees. Essentially, it is anybody who comes into the workplace can be protected by sexual harassment laws. The flip side of that, who is liable under the law? Essentially, the employer of the harassed associate and the harassed associate supervisor can be individually also held liable for other state law claims. In addition, the person who is the alleged harasser obviously would be held liable under the law. So we've got three kind of tiers of liability here. First, the employer. Second, the employee supervisor. And then finally, the employee or the individual who conducted in the harassing behavior.
So there are two types of sexual harassment claims. According to the EEOC, there are two types of claims, which are quid pro quo sexual harassment and hostile work environment sexual harassment.
All right, now we're going to take a little bit closer look at quid pro quo sexual harassment.
Quid pro quo sexual harassment describes a situation in which an employee is confronted with sexual demands in return for something that may benefit the employee, such as a raise, a promotion, or even the ability to keep their job. The request may be either explicit, such as, if you spend Friday night with me, you'll get that raise, or implicit, such as, people who are cooperative get better performance reviews. In quid pro quo sexual harassment, the harasser uses submission to submission to or rejection of unwelcome sexual advances, and other conduct of sexual nature as the basis for employment decisions, such as promotions, discharges, transfers, training, salary increases, or work assignments. Remember, it only takes one incident to get in trouble. A single sexual advance can lead to a lawsuit if it is linked to the granting or denial of employment benefits. Here's a true story of a quid pro quo sexual harassment. A manager warned an employee that her continued employment depends on her willingness to have a sexual relationship with him. After meeting him in the motel for more than a year, she suddenly ended the affair. Shortly after her performance appraisals were lowered, she was fired, and when she sued for sexual harassment, the company argued that it knew nothing about the affair. It also pointed out that no one forced her to go to hotels with the manager. In the U.S. Supreme Court decision, the employee's claim of sexual harassment was upheld. The court ruled that the company should have been more aware of the manager's conduct. It also dismissed the company's argument that she was a willing participant in the affair because it was made clear that her job depended upon her cooperation. The court also said that the fact that she was fired after ending the affair proved quid pro quo sexual harassment.
All right, now we're going to take a little bit closer look at the second type of sexual harassment, hostile work environment.
Hostile work environment or hostile sexual harassment occurs when an unwelcome conduct of sexual nature unreasonably interferes with an individual's job performance or creates a hostile, intimidating, or offensive work environment. Here are some examples of inappropriate behavior that creates hostile work environment. Sexual jokes or remarks, sexual cartoons, posters, or graphics, sexual innuendos, or suggestive looks. A victim does not have to suffer a concrete economic injury to build a case for hostile environment sexual harassment. For example, there does not have to be a loss of pay or promotion if the behavior in question interferes with the victim's work or creates a hostile work environment. It is sexual harassment. Again, it does not matter whether we think the employee has been sexually harassed. Every complaint must be taken seriously.
When we're looking at types of harassing conduct, again, this can include several different things: verbal, visual, or physical. When we take a look at the hostile work environment, when we look at verbal types of conduct, we've got a few kind of hallmark things that we're looking at here. Number one, obviously foul or obscene language. We don't want to be using inappropriate language in the workplace. We need to maintain our professionalism at all times. Again, we are coworkers and colleagues. We're not friends who are out, having a good time at the bar this evening. Second would be derogatory comments. Third, explicit discussions about sexual activities. And fourth, comments about other people's physical attributes. Again, we're not playing hot or not in the workplace. And for our third point there, explicit discussions about sexual activities. Just like you don't care what your coworkers are doing on their Friday nights, they also don't care what you're doing on your Friday nights. So we need to keep all conversations professional within the workplace and make sure that we're maintaining an air of austerity when we're interacting with our colleagues and coworkers. Second type of hostile work environment that you can run into is visual. And these are going to be things such as leering at other employees, staring at them, making sexual gestures, displaying sexually explicit objects, pictures, cartoons, graffiti, or posters, or sending graphic emails, text messages, or jokes. Again, anything that within the workplace, if somebody saw it, has the potential to make them feel uncomfortable, or in their own eyes or in their own perception, has a sexual nature to it. Again, as Tasha alluded to earlier, your intent behind the gesture is irrelevant. It was how it was perceived on the part of the third party who is making the complaints that carries all of the weight. The third type of acts that can lead to a hostile work environment comes to physical acts. And these probably seem fairly obvious here, and obviously we want to prohibit these within the workplace. Kissing, we should not be kissing our coworkers within the workplace. Hugging, grabbing, impeding or blocking movements. Simply standing in the way of somebody can be misconstrued and can be seen as sexual harassment on the part of the third party making the claim. And then fourth, obviously, assault. It goes without saying you should never be assaulting your coworkers within the workplace.
Okay. So in terms of victims of hostile environment sexual harassment, we all know that sexual, lewd, or pornographic pictures and jokes can create a hostile environment. But the sexual comment and lewd behavior does not have to be directed against a particular employee in order to prove sexual harassment. Anyone who is exposed to the inappropriate behavior can claim hostile environment sexual harassment. And here are some examples. A supervisor who sexually harasses an employee may be creating an intimidating, hostile, or offensive working environment for other employees who may have witnessed the offending behavior. A person who walks into a break room and hears coworkers telling sexually explicit jokes could file a complaint, even though the jokes were not directed at them. Flirting between a willing supervisor and an employee can be perceived as offensive if heard by another employee. So you see, all three of these examples may be deemed as hostile environment sexual harassment. Also, gender does not matter. The gender of the harasser and the victim of the are irrelevant when determining harassment. Courts also have slapped companies with large damage awards when the victim is a male employee harassed by a female manager or the same sex as the harasser. Also, employees who work off-site are also guaranteed protection against sexual harassment by employees and non-employees alike. One example may be a driver who is sexually harassed by a customer when making deliveries. If the supervisor does not take the company's complaint seriously and investigates immediately, the company can be held responsible for allowing the harassment to occur. Under the definition of third-party harassment, supervisors are responsible for preventing sexual harassment from anyone the company could exercise some control over. That includes customers, delivery people, supervisors or suppliers, as well as independent contractors. Consider any complaints that you receive in those areas just as serious as those that you would internal sexual harassment claims. There have been office affairs as long as there have been offices. So what's new? Companies that tolerate those romances can be found guilty of sexual harassment. Inter-office romances between supervisors and employees can be a lose-lose situation for all parties involved. The reason why is because when a supervisor dates an employee who works for him or her, other employees in the company may claim favoritism when it is perceived that the employee is treated positively. Also, when and if the relationship ends, the employee will often claim that they are the victim of retaliation. Here's another true example of an inter-office relationship turning into a lawsuit. A manager may be passed over for a better qualified employee for a promotion in favor of a subordinate who he was dating. The bypass employee complained to management, but nothing was done, so she filed a sexual harassment claim. The court said that the behavior of the manager in promoting a less qualified person because he was having an affair with her was clearly discriminatory. The company was ordered to promote the woman and take disciplinary action against the manager who was involved.
All right, now time to do a little bit of an exercise here, just kind of do a knowledge check and see how we're doing here. So for our example here, Blake is the sole proprietor of Acme Co., and he has decided to expand and compete for state contracts. So we're dealing with government-regulated contracts at this point. Blake hires Jack, an independent contractor, to install a computer network. Jill also responds to Blake's Craigslist ad for an office manager. Blake then threatens to sue Jack for breach of contract unless Jack agrees to engage in sexual activity. Blake also tells Jill the job is hers if she agrees to have sex. So Blake is clearly testing the limits of his authority here. So in this situation, let's choose the best answer. Do we think, number one, Jack can't sue Blake because he is an independent contractor? Number two, Jill can't sue Blake because Acme Co. has fewer than 5 employees. Number three, Jack can't sue Blake because he is a man. Number four, Jack and Jill can sue Blake for quid pro quo sexual harassment. Or number five, Jack can sue Blake for quid pro quo sexual harassment, but Jill cannot. Give you just a few seconds here to kind of think that over before we come back with the right answer. All right, do you have your answer in mind? The correct answer is number four. Hopefully that's what everybody picked here. In this case, both Jack and Jill can sue Blake for quid pro quo sexual harassment. So that is the correct answer here. Let's go through why the other answers are wrong. Jack can't sue Blake because he is an independent contractor. As we covered earlier in the session here, independent contractors are entitled to the same protections under sexual harassment laws as all other employees. Again, just because they're not a W-2 employee of the organization does not mean they don't get the same protections. Jack 100% could sue Blake for sexual harassment. Jill can't sue Blake because Acme Co. has fewer than 5 employees. Again, this is wrong because typically under state laws, you're not going to see any sort of provision requiring a minimum number of employees related to sexual harassment laws. The number of employees is irrelevant. Sexual harassment is sexual harassment and cannot be tolerated in the workplace. Number three, Jack can't sue Blake because he is a man. As Tasha alluded to earlier, while that may be an old and outdated and antiquated thought as it relates to sexual harassment, the courts have stood firm. Gender of either party is irrelevant. Just because both parties are male or both parties are female does not mean that sexual harassment has not taken place. And our last wrong answer there, Jack can sue Blake for quid pro quo sexual harassment, but Jill cannot. Again, this is just blindly wrong. In this case, why would Jack be able to, but Jill would not? Essentially, they tolerated the same level of conduct, and they would both be entitled to seek relief from damages. Second exercise that we have here. So we have Tamika. She has started as a supervisor for the commission in Yuba County. The other 4 supervisors and all the field crews at the office are men. So Tamika is the only female among the supervisors of the field crews. The district administrator, Eve, does not think women should be field supervisors and resents that headquarters is, quote, forcing an affirmative action case on her office. Eve is very clearly excited that Tamika is here working. Eve tells the other supervisors and crew members that the field is no place for a woman. A little bit of an outdated viewpoint there. She tells Tamika's crew to keep an eye on her and use your own judgment in the field. During office meetings, around the office, and in emails, Eve consistently refers to Tamika as, quote, little one, Wonder Girl, Oprah Jr., and other similar names. Tamika tells Eve that she is undermining her, but Eve tells her to grow a pair or you will never make it out there. Sounds like Eve is a great supervisor to be working for. So choose the best answer here. Number one, Eve's use of diminutive nicknames and undermining of Tamika's authority is okay because Tamika needs to demonstrate the ability to supervise men in what can be an inherently crude environment. She's just toughening Tamika up. That's all that's going on here. Number two, Eve's nicknames and statements undermining Tamika's authority have created a hostile work environment. Or number three, because Eve has no interest in Tamika sexually, her hostile behavior is not actionable as sexual assault. Give you a few seconds here again to think this one over, and we'll come back and go over the answers. All right, hopefully you've had enough time to think about it, and our correct answer is number two. Eve's nicknames and statements undermining Tamika's authority have 100% absolutely created a hostile work environment. So again, we'll go over the wrong answers here and why they're wrong. Wrong answer number one, Eve's use of diminutive nicknames and undermining of Tamika's authority is okay because Tamika needs to demonstrate the ability to supervise men in what can be an inherently crude environment. So this would essentially be considered discriminatory behavior because she is treating Tamika differently based solely on the fact that she is a female. She is stating that just because she's a female, she needs to demonstrate different qualifications and different characteristics than she would be holding a male counterpart to. So this would be considered sex discrimination, which under the laws is also considered sexual harassment. And our next wrong answer, because Eve has no interest in Tamika sexually, her hostile behavior is not actionable as sexual harassment. Again, I think as Tasha alluded to earlier, sexual intent or sexual desire is not required in order to meet the statutory requirement for sexual harassment. All that is required is that a hostile work environment has been created in order to generate an actionable claim. All right, so now we're going to get into the talk of severe or pervasive. This is an important concept when it comes to discussing sexual harassment. When we're thinking about a sexually charged or hostile work environment, how much is too much? Where is the line? Are there any common sense rules an employer can follow? Despite all that we've talked about here, we fully understand this can be a tricky thing to navigate. Obviously, we want to keep professionalism at the highest level possible, but with anything, there are going to be certain gray areas that we just need to know how do we navigate those. To be actionable, the unwanted behavior must be, quote, severe or pervasive, and it has to alter the conditions of employment to the extent that it creates a hostile or abusive work environment. So when we're determining what is severe or pervasive, we're going to take into account a few things here. Number one, the nature of the conduct. How severe was the nature of the conduct? Was it just so egregious that no reasonable person would take a look at this and say, that wasn't sexual harassment, or was it relatively minute and is open to interpretation? Number two, the frequency of the conduct. Is this happening regularly? Was this a one-time thing? Is it, how often is this occurring in the workplace? Number three, the period of time over which it occurred. Again, this is kind of very similar to frequency here, but we're looking at, is this an isolated incident? Was it relegated to a specific time period? When did the conduct occur? Number four, whether the conduct was physically threatening or humiliating. Did it create a hostile work environment to the point that the employee felt physically threatened, or they felt humiliated in front of their other coworkers or peers? And then number five, the extent to which the conduct unreasonably interfered with an employee's work performance. Did the alleged harassing conduct make it so that it was more difficult for the employee to discharge their duties in the course of a normal work day? All right, time for another quick knowledge check here with an exercise. So we've got Cody, as the unit supervisor for the board. Drew is an office technician, and he sits in a row of 5 open workstations right outside of Cody's office. On Drew's first day, Cody gives Logan, another office technician, so stay with me here, we've got 3 people here, Cody, Drew, and Logan. On Drew's first day, Cody gives Logan, another office technician, a lingering hug and kiss on the lips. Cody says, while looking Drew up and down, quote, "Welcome to Cody's world. If you remember just one rule, what Cody wants, Cody gets. You'll have a bright future here." The next day, Logan arrives early to work to be seated before Cody arrives. But Cody starts rubbing Logan's shoulders and says, "You can't stay seated forever." Drew sees and hears these interactions. So Drew's a third party at this point, and he is overseeing some conduct, which, my interpretation, definitely going to make some folks feel a little bit uncomfortable here. And it seems like Logan's a little bit uncomfortable in his work environment. Logan tells Drew what is happening, and Drew says, "Just get over it." Drew starts losing sleep and misses work because of Cody's mistreatment of Logan. So, we're going to choose the best answer here. Number one, Drew cannot state a claim for hostile work environment because Drew told Logan not to complain. Or number two, Drew has personally witnessed Cody's harassment of Logan, and therefore can sue Cody and the board for sexual harassment due to a hostile work environment. When we're talking about the board here, essentially we're talking about the company. So which do we think it is? I'll give you all a few seconds here to just kind of think about it, and then we'll come back and talk about the answers again. All right, hopefully I gave everybody enough time there, and our right answer is number 2. Drew has personally witnessed Cody's harassment of Logan, and therefore can sue Cody and the board, the employer, for sexual harassment due to a hostile work environment. When we're talking about why answer number 1 is wrong, Drew obviously probably didn't do the right thing by saying that he should just, that Logan should just deal with it. We would hope that our employees would be a little bit more forthcoming about it and supportive of each other. But just because he said that he should deal with it does not mean that he can't state a claim against their harassing behavior. It still has created a hostile work environment for Drew, and he can seek relief for that. So when we get back to the question of how much is too much, frankly put, there is no magic formula. Again, we're going to evaluate the frequency, the pervasiveness, in other words, and the severity of the conduct. The triangle below kind of demonstrates what we're looking at here if we had to quantify this. As severity increases, the frequency of the conduct, the required frequency of the conduct decreases. So one egregious incident may be all that you need in order to demonstrate sexual harassment, either from a quid pro quo or hostile work environment standpoint. On the flip side, if the conduct would be perceived as relatively minor, but we have it occurring over and over and over and over again, so we've got a high frequency of such conduct taking place, that just as easily may constitute sexual harassment. So again, when we're looking at this, we want to evaluate frequency and severity. The more severe the conduct is, the less frequent it needs to be. The more frequent the conduct is, the less severe it needs to be. Again, when we're looking at the line here, the courts are traditionally going to adopt what's known as the reasonable person test. So if we're looking at kind of the squiggly line there as the line for, quote, legal liability, we're going to draw that and say that is the reasonable person test, where anything below that line is definitely going to be considered sexual harassment. Anything above that line is going to be considered not sexual harassment. So the big question is, where do we want to be on that line? Obviously, we want to be as far above that line as possible. Again, the goal is not to just be above it, but as far as possible. And we're going to call that our safe harbor area. Essentially, when we're in the safe harbor area, what we can essentially determine is that our actions and that the way that we're treating each other is without reproach. We are treating each other with the utmost level of professionalism. We're treating each other as colleagues and coworkers deserve to be treated. Anything below the safe harbor line but above the reasonable person test line would be considered a risk area, where it's possible that it probably isn't sexual harassment, but that doesn't mean that it's not going to still be perceived as such and dealt with as such by the courts. Anything below the line is definite sexual harassment, and that's where the employer and you as the potential employee committing the sexual harassment has clear liability. There is no bones about that. When we look at workplaces in the 21st century, we're fighting a bit of a societal trend. Within society right now, we're seeing an increase in tolerance for sexual banter and conduct. I think the best example of this is just take a look at movies, radio, television from the 1960s, 1970s, and 1980s, and then compare that with movies, TV, radio today. The tolerance for sexual language, sexually charged language, innuendo, graphic depictions of sex acts. You'll see infinitely more in all of our media trends today than you would have even 20, 30, 40 years ago. By that same token, though, within the workplace, we're seeing a significantly diminished tolerance for that. Long gone are the days of the Mad Men work environment, where you can essentially say whatever you want, do whatever you want in the workplace. That should have never been the case in the workplace, and it definitely is not the case in the workplace anymore. All employees, all your coworkers, all your colleagues deserve to be treated with the utmost level of respect. So just keep this in mind, that while on the outside of the workplace, society as a whole may have a significantly higher tolerance for these types of things, within the workplace, the tolerance is almost zero. All right, now we're going to go into some key concepts here. Number one, As we kind of talked about earlier, sexual harassment can occur between individuals of the same sex. Again, it's been settled law for quite some time now that same-sex sexual harassment is actionable. The gender of the alleged harasser and the alleged victim is irrelevant. Number two, again, as we talked about previously, sexual desire is not necessarily required. An example of this in the state of California, recent legislation clarified existing law by expressly stating that sexually harassing conduct need not be motivated by sexual desire. The legislation in California, State Bill 292, was passed to repudiate the contrary decision in a prior court case called Kelly versus Conoco Companies. Number three, adverse employment action is not necessarily required. The complainant does not have to have a tangible economic loss or other adverse employment action. So just because you weren't fired, just because you didn't lose shifts, just because somebody didn't receive a dock and pay, does not mean that they were not sexually harassed and does not mean that they can't take action against that claim. The crux of any harassment claim is the assault on the complainant's personal sense of dignity and well-being. The courts, the legislature have clearly shown that sexual harassment at this point is a human rights issue and not an economic or workplace issue. Every single person in the world has the right to work in a workplace that is free of sexual assault and sexual harassment. All right, time for another exercise here. So Sam, a senior supervisor for the department, calls Maggie into his office. He tells her that if she'd like to avoid a bad review, she must perform a sexual act with him. He grabs her and pushes her to the ground. Maggie manages to escape Sam's grasp and flees. Josh sees Maggie running out of Sam's office in distress and thinks her blouse may have been partially off. Katie also sees Maggie in the restroom. She's crying and fixing a tear in her blouse. Maggie tells Katie about the attack. Sam abruptly promotes Maggie. Katie and Jose tell the Equal Employment Opportunity Officer what they saw and heard. Sam denies anything happened. Maggie then files a complaint with, in this example, the California Department of Fair Employment and Housing, but any state equivalent agency would be worthwhile as well, alleging quid pro quo sexual harassment. So let's take a look at the best answer here. So number one, Sam is a senior executive and no one witnessed the alleged unwelcome conduct, so no one's going to believe Maggie. Number two, because Maggie was promoted, she suffered no damages, so there can be no claim for quid pro quo harassment. Or number three, a reasonable investigator would conclude, based on circumstantial evidence and credibility assessments, that quid pro quo sexual harassment did occur. Again, I'll give you all a few seconds here to think about this, and we'll come back with our answer. All right, hopefully that was enough time for everybody. And our correct answer is number three. A reasonable investigator would conclude, based on circumstantial evidence and credibility assessments, that quid pro quo sexual harassment did occur. Again, this one seems pretty cut and dry here based on the previous facts we showed in the exercise, but let's go ahead and go through the wrong answers. Number one, Sam is a senior executive and no one witnessed the alleged unwelcome conduct. When it comes to sexual harassment, rank of the employees is irrelevant. Again, as we've talked about, sexual harassment is essentially being considered a human right in the workplace at this point, so it does not matter who the offender is or who the alleged witness is. Everybody is held accountable and everybody is held to the same standard of conduct. Number two, because Maggie was promoted, she suffered no damages, so there can be no claim for quid pro quo sexual harassment. Again, as we talked about on a previous slide, just because there was no adverse employment action, i.e. failure to promote, dock in pay, dock in hours, termination, anything like that, does not mean sexual harassment did not take place. Again, the crux of the issue is whether or not there was an assault on the complainant's dignity and sense of well-being within the workplace. All right. So from the employer's side, what are the reasonable defenses that can be made? Number one, the first is that the victim could have avoided part or most of the harm if they had taken advantage of the employer's procedures for addressing sexual harassment. This is what's known as the avoidable consequences doctrine. Or number two, the amount of harm to the victim could have been less if the employee had taken action. And this is known as the failure to mitigate damages doctrine. All right, time for another exercise here. So we have ABC Company. ABC Company provides all employees a handbook that details ABC's zero-tolerance sexual harassment policy, much the same fashion that BC Forward has a handbook that we provide to all employees that clearly details our sexual harassment policy. It instructs employees to call ABC's HR department immediately if they experience or witness any sexual harassment. Again, very similar to BC Forward's employee handbook that requires immediate reporting of any sexually harassing behavior or perceived sexual harassment. Quinn is an ABC supervisor. So she's a supervisor working for ABC Co. Walks by Pat's desk and whispers to Pat that he should, quote, forget to wear undergarments the next day. Pat is shocked and pretends not to have heard. From then on, Quinn whispers similar comments to Pat every opportunity they are alone in the office. Pat does nothing, thinking it is only a matter of time before Quinn, who is an incompetent supervisor, is replaced. After 6 months, Quinn is terminated for poor performance, at which point Pat recounts all of Quinn's past actions to a senior executive and asks the manager to make sure the next supervisor is, quote, less disgusting. So it sounds like Pat put up with quite a bit for 6 months and just waited for Quinn to essentially leave the company. So let's take a look at our answer choices here. Number one, Pat cannot sue anyone for sexual harassment because 6 months have gone by, and Pat waited until Quinn was fired before anything was shared with management. Number two, Pat can sue both Quinn and ABC, but ABC can try to reduce the amount it must pay by arguing that the harassment would have stopped if Pat called HR after Quinn's first comment. Number three, Pat can only bring a claim against Quinn. ABC is not liable because Pat chose not to follow the instructions in the employee handbook. All right, and our correct answer here is number two. Pat can sue both Quinn and ABC, but ABC can try to reduce the amount it must pay by arguing that the harassment would have stopped if Pat called HR after Quinn's first comment. Looking at our wrong answers here. Number one, Pat cannot sue anyone for sexual harassment because 6 months have gone by, and Pat waited until Quinn was fired before anything was shared with management. The 6 months here refers to, what is the statute of limitations on filing a claim of sexual harassment? 6 months is well within that guideline. And just because the employee is no longer, the offending employee is no longer an employee, does not mean that the time to file a claim has expired. And our second wrong answer there, Pat can only bring a claim against Quinn. ABC is not liable because Pat chose not to follow the instructions in the employee handbook. Again, just because Pat did not follow the instructions in the employee handbook does not mean that sexually harassing conduct did not occur and a hostile work environment was not created. Pat is still entitled to file claims. Obviously, from the employer's side, we would prefer that all of our employees file with us first so that we can attempt to deal with the conduct internally. But in most states now, there are provisions where the employee must also be authorized to file directly with a government agency. All right, so now we're going to talk about how do we prevent and respond to sexual harassment. Here's 5 tips for how to avoid liability for a sexually hostile work environment. Number one, do not become too familiar with your coworkers. Do not have a relationship with anyone in your chain of command. Again, both of these things are pretty clearly outlined in the BC Forward Employee Handbook. When it comes to becoming too familiar with your coworkers, obviously we recognize that in today's day and age, we spend quite a bit of time with our coworkers. However, we want to make sure that those relationships stay professional. So while they can be congenial, we still need to respect the fact that these are our coworkers and colleagues, and we're going to have to work productively with each other in the coming days to ensure the success of the company. Second part of that, do not have a relationship with anyone in your chain of command. Again, in the BC Forward Handbook, it is expressly prohibited for anybody to have a romantic relationship with any other employee who is within 2 steps of their direct chain of command. So this is expressly prohibited as a matter of BC Forward policy. Number 2, Don't make sexually suggestive remarks or comments or tell sexual jokes offline or online to anybody's face or behind their backs. A common misconception is that just because a bunch of coworkers are not at the office, anything that is said during that interaction is no longer held liable under the same sorts of sexual harassment standards. This is simply not the case. When you're discussing or interacting with your coworkers, anything that you are saying can be held under the same standards as it would if you were in the office workplace. Number 3, avoid using pet names. Do not call others honey, dear, babe, sweetheart, or other terms of endearment. Do not refer to women as girls or gals. Again, although we may think that we're just being sweet and homely with each other, we want to make sure that, again, we're respecting the professionalism and we're respecting the dignity of each other. And so we need to use proper names and proper titles for everybody when we're talking with them. Number 4, respect each other's space. So make sure that we're respecting everybody's personal bubble. Do not place your hands or other body parts where they should not be. This seems like a basic rule that's taught, essentially in preschool and kindergarten, but your hands belong to yourself. Don't violate anybody else's personal space requirements. Number 5, do not comment on anyone's sex life or body parts, including your own. Again, as we talked about earlier, just as I don't want to hear about anybody else's sex life, they don't want to hear about my sex life. So we don't need to be sharing those things at the workplace. Again, ultimately, keep it professional, keep it congenial, but remember these are your coworkers and colleagues, and we're not boys and girls in the gym locker room. Remember, if a video camera were capturing behavior, would you be comfortable with, number 1, your manager viewing it, your family viewing it, or your friends viewing it? So kind of keep that in mind. If your spoken or your written words were entered into evidence, would you be comfortable with an opposing attorney seeing or hearing them, a judge seeing or hearing them, or a jury seeing or hearing them? Again, when we talk about sexual harassment and hostile work environment, your intent behind the words or your intent behind the action, frankly, is becoming irrelevant. What matters is the perception of the complainant. How did they perceive your words or actions? Again, some other common sense rules to avoid sexual harassment claims. Do not say or do anything at work that you wouldn't want said or done to your mother, father, grandmother, grandfather, daughter, or son when they are in the workplace. Number 2, don't say or do anything at work that you would not want on the front page of the newspaper. All right, so now a little bit of a dive into what are your responsibilities in the workplace as it relates to sexual harassment.
Providing a professional atmosphere free of behavior that interferes with an associate's ability to work efficiently and effectively. Supporting and enforcing your equal employment opportunity and non-harassment policies consistently and vigorously. And communicating with coworkers, supervisors, clients, and public in a professional manner. Some additional obligations you have, and these really should be obligations that you have even outside the workplace as well. Number 1, monitor and control your own behavior to avoid even the appearance of impropriety. I had a manager a long time ago that told me perception is reality. And while that might not be factually true, as far as everybody else sees it, pragmatically it is often true. How your actions and how your words are perceived is the reality that is generated around them. And again, as we've discussed over and over again here with sexual harassment, your intent behind the actions are irrelevant if they're reported as sexual harassment. What is important is the perception of your words or actions on the part of the person who reported them. Number 2, report anyone else's behavior if it does not meet the standard. Again, as it's outlined in the BC Forward Employee Handbook, anybody who is considered a supervisory level employee is required to report to us anything that could be considered sexual harassment, and we obviously would strongly encourage anybody, even if they're in a non-supervisory level, to report anything. I'm going to take you back to your schoolyard days here. If you see something, say something. Let us know. As a company, we're always trying to get better and make sure that our resources have the best time on projects as possible. But
that's only possible if we have your support as we're doing this. Any information you can provide to us only helps to make us better.
So, as a supervisor, when an employee informs you of harassment, you are to treat all complaints of sexual harassment very seriously. Don't try to distract or make light of the move by making humorous remarks that could possibly be misinterpreted. You'll also want to let the person know that the complaint will be taken seriously and investigated completely. Listen without passing judgment or jumping to conclusions, and don't assume that the alleged harasser couldn't possibly have done what the victim is alleging because the person doesn't fit your image of a sexual harasser. And lastly, if an employee complains about sexual harassment, report it to Human Resources immediately. Once a supervisor becomes aware that the sexual harassment is taking place, it is their responsibility to report the behavior, whether he or she witnessed it personally or becomes aware of it through conversation or third-party involvement. Keep in mind, slow or inadequate responses to allegations of sexual harassment sets the company up for future lawsuits. Even if we fired the alleged harasser, the court could rule that we acted too late, subjecting the employee to further harassment, or that we waited to act after the victim filed a lawsuit. Many victims of sexual harassment either don't report the harassment or hold out and deal with it themselves as long as they can because they're concerned about the potential repercussions of coming forward. But it is important to ensure the victim that our company does have a strict non-retaliation policy. Supervisors are also required to report all possible incidents, even if the potential victim is reluctant to come forward. You cannot promise confidentiality, but you can tell them that you will only inform those who need to know. In terms of reasonable steps, employers must take all reasonable steps to prevent discrimination, harassment, and retaliation. A determination as to whether an employer has complied may include an individual assessment depending upon numerous factors, sometimes unique to the particular employer, including but not necessarily limited to the workforce size, the budget, the nature of the business, and the facts of the case. The employer is also obligated to conduct an effective workplace investigation of harassment complaints, and we should conduct a thorough interview of all the complaining parties, give the accused party a chance to share their perspective of the event. We also interview relevant witnesses and obtain all relevant documents. We investigate all relevant avenues applicable to the allegations, and then reach a reasonable, fair conclusion based upon all facts. Now, I talked a little bit about reporting and anti-retaliation, and BC4 does have a strict non-retaliation policy. Employees have the right to communicate all problems, suggestions, or issues to any supervisor, and the no retaliation policy applies to all official or unofficial reports. Please note, all complaints and investigations will be kept confidential. If an employee files a complaint for another employee, BC4 will take it seriously and investigate thoroughly. If immediate action is required, BC4 will ensure the employee who filed the complaint is not affected in any way. However, the alleged wrongdoer may see their employment or position affected until the investigation is concluded. If you should have any questions regarding sexual harassment and what may be deemed as sexual harassment, you can definitely refer to the employee handbook at any time. When reporting harassment, BC Forward takes allegations of harassment and violations very seriously, and it urges employees to report to your supervisor, managers, or HR department. You can also report any claims of sexual harassment to the department or Delaware Department of Labor, and here's the number.
All right, so again, as we've talked about here, just kind of your obligations and your role and responsibility as it relates to sexual harassment. The biggest thing that I want everybody to take away here is that we need to modulate our behavior and we need to calibrate it to the professional expectations that we have within the workplace. Again, using those couple simple tests that we put out for, previously. Would you want your parents hearing about what you did? Would you want a judge, a jury, opposing counsel hearing about what you did? Would you want to read your behavior as the headline on the front page of the newspaper? So think about that. If not, you need to change your behavior. Adjust yourself to the professional expectations that BC Forward has of you, and adjust yourself to just make sure that we're treating everybody with a level of professional respect that every person is deserving of. Now we're going to talk about some other types of harassment and abusive conduct. So in BC Forward's handbook, we outline quite a few different protected statuses for our employees. Harassment based on any of these is strictly prohibited. Again, within our handbook, we clearly outline this, but BC Forward recognizes the following at a minimum as protected statuses: age, race, ancestry, color, national origin, ethnicity, religious creed or belief, physical or mental disability, marital or familial status, legally protected medical condition, genetic information, military or veteran status, sex, which includes pregnancy, childbirth, breastfeeding, or related medical condition, gender, which includes gender identity and gender expression, sexual orientation, citizenship status, protected activity, and any other status that is protected by applicable law. So again, any harassment that has its basis in any of these protected statuses is strictly prohibited. Some examples here that we're going to go through. I'm going to say the examples. I don't want to ever hear about these examples being used in our workplace. Examples of national origins would be making an offhand remark that somebody is, quote, probably an illegal, quote, somebody is still wet, quote, somebody is a rage head, or making fun of someone's accent. 2, age discrimination. Something as innocuously or seemingly innocuous as, quote, can't teach an old dog new tricks, or that person is old and tired. Those can be perceived as age discrimination and are strictly prohibited under our harassment procedures. Race. I'm not going to go through these specifically, but we all know the types of derogatory words that have been used and should never, but unfortunately should never be used in the workplace. So when we're talking about abusive conduct, this is any conduct in the workplace that a reasonable person would find hostile, offensive, and unrelated to an employer's legitimate business interests, including 1, repeated infliction of verbal abuse, such as the use of derogatory remarks, insults, and epithets. 2, verbal or physical conduct that a reasonable person would find threatening, intimidating, or humiliating. Or 3, the gratuitous sabotage or undermining of a person's work performance. While a single act does not necessarily constitute abusive conduct unless it is especially severe and egregious. Abusive conduct on its own does not constitute an independent cause of action. So when we're talking about a cause of action, what that means is ability to seek relief for damages. So again, abusive conduct, e.g. bullying, does not necessarily constitute an independent cause of action unless it can be shown to have been substantially motivated by a protected characteristic. So again, think about that long list of protected statuses we just went over earlier. If it can be shown to be related to any of those, we do have an immediate cause for action at that point. There is, however, a possible claim if violence or the threat of violence is involved. Additionally, there are possible non-EEOC claims, like criminal claims if assault, battery, or intentional infliction of emotional distress are involved. Time to go over a few more exercises. So we have Carl. He's been a manager for the board for 5 years. Carl approaches another manager, Terry, and tells him that she identifies as a transgender woman and is beginning the process of transitioning at work. From now on, Carl would like to be called Kay, will be wearing clothing consistent with an identity as a woman, and prefers the use of feminine pronouns. As the weeks pass, Kay's coworkers become accustomed to her new name and appearance, but some of them inadvertently refer to Kay as Carl and use the masculine pronoun he. especially when telling stories about things that happened before Kay's transition. Usually, the coworkers quickly correct themselves when this happens. Terry, however, pointedly says, "Good morning, Carl," when Kay passes by, and makes comments like, "Nice dress, dude." Kay, embarrassed, says nothing to Terry or anyone else about these comments for months. So when thinking about this situation, let's choose the best answer. Number one, Kay should keep her head down and try to focus on work. Not everyone's going to be comfortable with her gender transition, and she should expect some negative comments or remarks. Number two, Kay has a claim for discrimination and harassment because of gender identity and gender expression against the board because of Terry's treatment of her, as well as because of her coworkers' occasional use of the wrong name and pronoun. Those coworkers should be reprimanded and notes placed in their files. Or number three, Kay has a claim against Terry and the board because of Terry's negative comments and purposeful repeated use of the wrong name and pronouns. Her coworkers' occasional and accidental mistakes, however, do not create a situation of discrimination or harassment. So again, I'll give you a few seconds to think about this and we'll come back and talk about the answers. All right, hopefully that was enough time for you. And our right answer is number three. Kay has a claim against Terry and the board because of Terry's negative comments and purposeful repeated use of the wrong names and pronouns. Her coworkers' occasional and accidental mistakes, however, do not create a situation of discrimination and or harassment. So that's the right answer. Let's go over the wrong answers here. Number one, Kay should keep her head down and try to focus on work. Not everyone is going to be comfortable with her gender transition, and she should expect some negative comments and remarks. So again, when we're looking at harassment, anything like this, we're talking about maintaining the respect and dignity of the individual in their workplace. Everybody has the right to maintain that while they're working. Just because you as an employee might not agree with somebody's lifestyle does not mean that you need to voice those concerns at the workplace. In fact, not only should you not voice those concerns, you are prohibited from voicing those concerns. Again, your personal opinions are your own personal opinions. They're exactly that, personal. They are irrelevant to the workplace and need to maintain their status outside the workplace. Your personal feelings on what Kay is doing here would be irrelevant to Kay performing her work and discharging her duties to the best of her ability. Number two, Kay has a claim for discrimination and harassment against the board because of gender identity and gender expression, as well as against her coworkers' occasional use of the wrong name and pronoun. So this one's kind of a half point here. So I'll give you partial credit if you guess this one. So the first part of this is correct. Yes, Kay absolutely has a claim for discrimination against Terry. Terry is clearly, willfully, and knowingly referring to Kay by the wrong name and discriminating against her based on her gender identity and gender expression. So that's the right part of this one. The wrong part of this one is against the coworkers' occasional use of the wrong name and pronoun. If you remember from the exercise, they typically said that when this is done, it's when they're reminiscing about old stories prior to Kay's transition. There's no malicious intent here, and they quickly correct themselves, again, as it was said in the exercise. So while Kay has a complaint against Terry, there wouldn't be anything actionable against the coworkers who, again, are just doing the best that they can when they're talking about these older stories. Another exercise. We've got Jason. He's a new employee at the authority and having difficulty learning the office protocols. He asks his supervisor, Ming, for assistance. In a loud, sarcastic voice, audible throughout the open workstation area, Ming tells Jason, "I've showed you how to do this simply simple, 3 simple step procedure over and over and over. You should have been paying attention. I won't show you again." So Jason is trying to learn. It sounds like he's having a bit of a hard time. Ming, clearly tired of showing Jason what he needs to do, and maybe goes off on him a little bit in the office here. So choose the best answer. 1, Jason can sue Ming for abusive conduct. 2, Jason should have paid better attention earlier. Number 3, Ming's actions constitute abusive workplace conduct and can be likely disciplined for violation of workplace behavior policies. Or number 4, Ming's conduct exposes the authority to liability for unlawful discrimination. And I'll give you a few seconds here and we'll come back and talk about the right answers. right, hopefully that was enough time for everybody. And our right answer is number 3 here. Ming's actions constitute abusive workplace conduct and can be likely disciplined for violation of workplace behavior policies. So let's go through the wrong answers here. Jason can sue Ming for abusive conduct. Again, as we discussed earlier, abusive workplace conduct is not necessarily an independent cause of action unless you can show that it's directly tied to one of the protected statuses we talked about earlier. In this case, while it's definitely abusive verbal behavior, it's not tied to any protected status because it's simply his frustration that Jason hasn't been able to grasp the concept that Ming has tried to show him a few times. So there's no need to engage in legal suits here. Number 2, Jason should have paid better attention earlier. While this may be the case, Jason may have been needed to pay a little bit better attention earlier. That does not warrant the level of severity of conduct that Ming exhibited when Jason asked for help again. Obviously, we want any of our subordinates or any of our employees to pay attention, grasp things as quickly as possible. If they need additional help, though, or they're not getting something in the timeline that you want them to get into, exploding on them in the manner that Ming did is entirely uncalled for and is only going to result in a negative workplace environment there. And number 4, Ming's conduct exposes the authority to liability for unlawful discrimination. Again, kind of like we talked about with the first one there, there's nothing in Ming's conduct that ties anything to a protected status, so it's going to be hard to do anything as far as unlawful discrimination goes. On to our next example. We're continuing the saga here between Ming and Jason. So after this whole outburst, Ming then proceeds, he can't leave well enough alone. Ming writes an email to Jason, which reads, quote, "Jason, are all Irish mutts as stupid as you? What is it about that thick potato head of yours that you can't understand the most simple instructions?" So Ming has escalated things a little bit here now. So let's look at our possible answers for this situation. So choose the best answer. Number 1, Ming would likely be found personally liable for harassment based on race, ancestry, or national origin. Number 2, the authority is strictly liable for the harassment by Ming, his supervisor. Number 3, Jason can recover damages from Ming personally. Or number 4, all of the above. Again, we'll give you a few seconds here and we'll come back and talk about the right answer. All right, hopefully everybody had enough time there. And our correct answer is number 4, all of the above. So again, if you guess anything other than all of the above, I'll give you some partial credit on this question. But in this case, all 3 answers are right. Ming absolutely can be found personally liable for harassment based on race, ancestry, or national origin. The authority is definitely liable for the harassment by Ming, and Jason can recover damages from Ming personally. So all of the above in this case.
Okay, so we appreciate your participation and hope that we have provided useful information regarding the elements of sexual harassment and remedies available to victims of sexual harassment, other forms of unlawful discrimination, harassment, and retaliation, strategies for preventing and responding to unlawful discrimination, harassment, and retaliation, and lastly, abusive conduct in the workplace. Again, if you have any questions regarding any of the material, you could definitely reach out to myself, Tasha Irvin, Employee Relations Manager, or Jacob Pruitt, the Compliance Manager here at BC Forward.
All right, thanks, Tasha. A couple last-minute contact information here. If you want to get in touch with us by email, please feel free to reach out to us at support@bcforward.com. Again, that's support@bcforward.com. And we'll traditionally get to those requests as soon as possible. Thanks again for everybody's attention today. We hope this was a fun, informative session for you, and have a great rest of your day.